Today we're going to be talking about sex segregation and why it is a scary form of sex discrimination.
I'm going to talk about the access of women to the military academies and share with you some of my experiences in litigating access to the Virginia Military Institute and the Citadel. And then I will talk about U.S. versus Virginia, which was the Supreme Court's determination that access to institutions like VMI and the Citadel, because they are public institutions, federally funded, with state and federal monies that come from men and women, cannot exclude women. I will use the discussion of U.S. v. Virginia to begin the discussion on the standards for justifying any sex segregation in public education, and that the other members of the panel, I think, are going to really carry that further. We'll be very excited to hear what's going on in D.C. from Monica, and Sue has been doing research on this for a very long time and will share that research with us. So let me first give you a little background on the United States Service Academies. These are 5, and they are, the purpose of the institutions that I'm going to introduce to you are to train commissioned officers for the United States Armed Forces. This includes West Point in New York, founded in 1802, the Naval Academy in Annapolis, Maryland, founded in 1845, the Coast Guard Academy in New London, Connecticut, founded in 1876, the Merchant Marine Academy in Kings Point, New York, founded in 1943, and then the Air Force Academy, Colorado Springs, Colorado, founded in 1954. These institutions were all men, founded, only men could be enrolled, and as a result of legal action that were initiated by women who were interested in attending, Public Law 94-106, requiring the admission of women to the U.S. Service Academy, was passed in 1975 by the House of Representatives on a vote of 303 to 96, and by voice vote in the Senate, after very divisive argument within the Congress, within the Senate, with the Department of Defense totally against it. Gerald Ford signed the bill in 1975, and in 1976, 300 women enrolled in the U.S. Military Academy in West Point, the U.S. Naval Academy in Annapolis, and the U.S. Air Force Academy. Male prejudice continued at these institutions. That was the biggest obstacle to their enrollment. The schools reconfigured barracks, dormitories, locker space, adapted physical education requirements, and today, women are included in all aspects of the military, but the issues of integration continue as there continues to be sexual harassment and sexual violence against women in the military, including at the academies. The 6 U.S. senior military colleges that I'm going to focus on next are public institutions. They're basically U.S. Academy wannabes. The lead litigator in the Citadel calls it military play school. It's a little more than that, I must admit. It was in one of his down moments, I believe. But I've worked in policy and litigated issues around women's access to education, women's protection from sexual harassment and sexual violence, access to STEM programs, access to women in athletics, leadership. And I've always been emotionally supportive of these issues. When I was working on the Citadel case, I didn't feel that way. I thought, why do these women want to go to this institution? I could understand the legal theory, but I must admit, at the end of the day, I understood, and I'm going to share that with you. It took a bit, and the experience had some really horrifying moments, but I do want to say, at the end of the day, I understand why the women wanted to also have the same opportunity as the men. So there are 5 of these senior military colleges in the United States. They are Norwich University in Norwich, Connecticut, Texas A&M University Corps of Cadets, the University of North Georgia, Virginia Military Institute in Virginia, the Citadel, or the Military College of South Carolina, and Virginia Tech, the Virginia Tech Corps of Cadets. So with the integration of women into the U.S. military academies, questions were raised, particularly in Virginia, about why women didn't have access to VMI. And so the VMI decided to commission a committee of 4 men only to study the issue for them. And they visited all the academies that had integrated women for years and interviewed the women cadets and graduates, their faculty, the officers, and they determined that women were successful, and the program was successful. An integrated program, men and women, was successful at all these institutions. They concluded that the women at the military service academies, that the women's interests and needs were being met by the academies, and therefore there was insufficient interest to attend VMI because it was being met. Therefore, their conclusion was keep VMI men only. It was unexpected and strained at best. They said there wouldn't be a critical mass of women, that women couldn't support each other, and it would be unfair to them. Not enough interest. So, thus it remained for individual women to go forward. The in 1989, a woman filed a complaint with the Department of Justice. And it's interesting that she wanted to get into VMI. Her identity has never been revealed. The Justice Department has, from the beginning, not identified this young woman. And the Justice Department took on her case, and there began a political struggle within the state of Virginia, where the Board of Visitors of VMI was vehemently against it, citing to this study. And the political leadership in Virginia was sort of mixed. There was a governor who wanted to open it up, and there were members of the legislative body who were interested, but it was always contentious. And this went on for about 5 years, and the Board of Visitors prevailed, and the Justice Department and the individual finally brought a case before the Supreme Court. And on the basis that not to admit women would be a violation of the Equal Protection Clause, 14th Amendment of the Constitution. And in 1995, the court accepted for the 1995 October term this case. And that's where I became involved. We were litigating a similar case in the Citadel. It took a little different litigation process than the VMI. Shannon Faulkner, who was a high school student in Powdersville, South Carolina, was 18 when she applied in 1993 to the Citadel. She did not reveal her gender at all. She kept all reference to the fact that she was a young woman from her application information, and she was accepted. When the Citadel learned that she was a woman, they said, "We are reneging on our acceptance. You are no longer welcome." She filed suit in March of 1993, alleging violation of the Equal Protection Clause. And the United States intervened in June of that year. By court order, she was admitted to the day program, because the court determined, the district court, Judge Houck, determined that he didn't want to wait for the fullness of the VMI litigation. He was viewing what was going on in Virginia, and there was a lot of that political bantering. So he thought that to deny her admissions that she would have gotten other than for being a woman was not appropriate. And by court order, he determined that she should be admitted, and the Citadel admitted her to the day program.
To the what program?
Day.
Daytime, okay.
So, he also said that even though she was admitted, he was aware that there had to be some changes in policy, and he ordered the Citadel to come up with an assimilation plan to make sure that women would be assimilated appropriately, because he was already getting evidence that there was a lot of harassment, hazing against women, and within a week, Shannon Faulkner had left, citing that emotional and psychological abuse had occurred, and she was physically exhausted. So it was left to a young woman named Nancy Millett to take up the case as the plaintiff. 20 years later, Faulkner said that her parents had been threatened with murder, and she just couldn't. She, in all good conscience, she said, "I just couldn't stay the male cadets were so angry that women were admitted, they had licenses that identified the number of cadets at the Citadel, and the number was there, plus one BITCH. So it was clear that there was a need for an assimilation plan. But the Citadel kept dragging their feet, and by August, and there's a tradition of a 7-month hazing period for new cadets, the Knob year. The idea is to tear down the spirits of the cadets in order to build them up, to make them citizen soldiers. And so this happens during these first 7 months. It's supposed to build a bond with the cadets and eventually build the bond to their tormentors and make them all members of the cadets. 7 months. So after 3.5 months of this, and hearing about things like women who were smaller in stature being placed in formation in their groups so that they had to march on the outer edges, and the women kept ending up going to health service because they had stress fractures, and they were just physically more hurt than the judge was happy with. And then finally, in August, late August, early September of that first year, towards the end, maybe the 4th or 5th month of the hazing period, 2 women were set on fire. There was, they actually went into the barracks and threw lighter fluid or nail polish remover on them, knowing that if they lit them, it would evaporate so quickly it wouldn't really burn them. But it scared the bejesus out of them, you can only imagine. And they left. I mean, so the judge finally said, you know, we need that assimilation plan. And we started working with them on that. In the meantime, both Virginia and South Carolina decided to try a separate but equal approach. And this was to set up parallel programs at Mary Baldwin for VMI. It was called the Virginia Women's Institute for Leadership. And in South Carolina, it was the South Carolina Institute for Leadership. And the curriculum was different. There was no history of networking, because both of these, VMI and South Carolina, at the Citadel, if you graduated, you got this big ring and you got a network that would guarantee power to the economic structure and the political structure. The courts determined that neither of these parallel programs for women could meet that requirement, therefore it wasn't an equal education. So, let me just say that eventually the women admitted to the Citadel were treated the same way. Their hazing was no better and no worse than the men. No more setting them on fire. And finally in March of 2001, when they could prove that there was adequate treatment, adequate assimilation, the U.S. and the court determined that the Citadel had met its remedial obligations. But back to Virginia, and I want to talk a little bit about the U.S. v. Virginia so I can segue into the standards for sex segregation. But before I do that, I want to talk to you a little bit about the ring at the Citadel. When we were negotiating the assimilation plan with the Citadel leadership, they were planning to give the women graduates a ring that was similar in design to what they called a sweetheart ring that they gave to their wives, their mothers, and their sweethearts. It was a smaller ring because the women were so delicate. So it really bothered me because I kept seeing these big pictures. If you go online now, you see this ring. This is what all the guys wear. It's kind of like when the sports teams win their championships. So the ring is important. But my colleagues said, oh, we've got so much we've got policies on sexual harassment, athletics, equity. Give it up, Jeanette.
No, but it's a symbol, right?
Absolutely.
Right.
But I was the only one on the team who felt strongly about it, and we did have a lot to fight through. So but I want to tell you, on the final day where the judge was going to resolve the case, I actually had to go back and listen to it because he became my hero. He actually said, I went home he's kind of a character. I went home last night and I don't usually dream about things like this. He's talking about the assimilation plan. But I went home and started thinking about this plan, and I know you all do the same thing, talking to us and with Citadel, and started running things through my mind. This is the judge. I told myself, don't be an idiot. Leave it like it is. Yeah, but the only thing I'm going to add is one sentence. And that is, all qualified male cadets shall be given the opportunity to receive the ring. Well, I just went over the top. I was so happy, and everybody on our team was sort of giving me a pat on the shoulders. Because he actually read the resolution and came up with this requirement. He says, I don't know how else to describe it, except I want it put in caps. So in the resolution, the only thing in total caps is V, T-H-E, ring, R-I-N-G. The ring that has been historically given to male graduates of the Citadel Corps of Cadets under the same circumstances as said male cadets have received the ring in the past. The women cadets need to receive it, and so we are going to add that to the plan.
Congratulations.
Made my day.
Symbolic.
Anyway, back to the case. This is U.S. versus Virginia, determined by the Supreme Court at the end of their term because it was controversial, June 1996. The Supreme Court had heard oral argument in January. Judge Ruth Bader Ginsburg wrote the opinion of the court, and it was concurred by Justice Stevens, O'Connor, Kennedy, Souter, and Breyer. When she read the opinion from the court, she made strong eye contact with her fellow female, Sandra Day O'Connor. Rehnquist filed an opinion concurring in part. He was Chief Justice at the time. And Scalia dissented. Thomas took no part in the opinion. RBJ wrote that generalizations about what is appropriate for most women no longer justify denying opportunity for all women. Rights adhere to the individual, not to the group of which she is a part, whether or not generalizations about the group may be correct. Judge Scalia dissented by stating that the court was reading its own values into the Equal Protection Clause. He relied on original intent, not a surprise, holding that the court should be bound by the fact that women were not considered equal when the 14th Amendment was ratified in 1868.
You told the truth.
He told the truth.
That is the truth.
However,
At that time.
in the actions of the U.S. elected representatives with the passage of the 1964 Civil Rights Act, the 1972 Education Amendments, Title IX, and other legislation that clearly indicated that equality had become a firm component of the culture of the United States. And people wished to give the meaning to the Constitution. The basic holding of the United States in this case is that, and this will segue into the discussion of my co-presenters, is that parties who seek to defend gender-based government action, such as single-sex education, must demonstrate an exceedingly persuasive justification for that action, exceedingly persuasive. To meet the burden of justification, the state must show that the challenge classification serves important government objectives and that the discriminatory means that are used to serve that objective are substantially related to the achievement of those objectives. The justification must not rely on overbroad generalizations about the different needs, talents, capacities, or preferences of males and females. In the case of VMI, the justification, and this was the VMI case, for excluding all women from being citizen soldier training, for which some are qualified, does not meet.
And the Department of Ed made that more seemingly allowable by changing the regulations. So just in case you're interested, the numbers that we have in our most recent report are there 723 co-ed schools with single-sex classes that we could identify by the name of the school based on data from the Civil Rights Data Collection. And that data, the most recent data we have was just for 2013-14. And then we found, by looking at data on enrollment from the CRDC, those that had all-female or all-male enrollment of students, we found 130 of those schools. Just out of curiosity, do you think there are more public single-sex girls' schools than public single-sex boys' schools?
No.
You're wrong.
Oh, no.
There actually are 73 public single-sex girls' schools that we identified, and only 57 single-sex boys' schools. But when we looked at the classes that were offered in co-ed schools that were only for girls or boys, we did find that more of those classes were just for boys. So that's kind of interesting by actually looking at what's happening now, and we'd like to learn more because more schools keep appearing, sadly.
Are you including charter schools in that?
Public charter schools are included, yes. So I will also mention that we have sort of three major types of concerns that we hope that you all can share with others as you try to fight battles against sex-segregated public education. First of all, public education is somewhat different than private education. Public education, we're saying all things that are covered by recipients of federal, financial, or other types of assistance. So those schools are not allowed to have sex segregation. And we're mainly, in our research, have been talking about K through 12 schools, but many of the things that we're talking about also apply to post-secondary schools as well, which uniformly are not, that almost all post-secondary schools are covered by Title IX because they receive or allow their students to receive federal financial assistance. So there are only 4 or 5 post-secondary schools that aren't covered by Title IX. However, they're grandfathered in, or grandmothered in. Some private schools don't have to admit boys or girls in their undergraduate programs. They can be single-sex, and you know there are single-sex schools, but even schools, for example, like Trinity here in DC, when they have graduate programs, those graduate programs must be co-ed. So there's all kinds of little distinctions that we need to know about. But anyway, it's important to know the legal objections to sex discrimination. And exclusionary sex discrimination generally violates Title IX, the U.S. Constitution, and some state constitutions or statutes, as well as specific laws that protect against race and sex segregation and discrimination related to sexual orientation and gender identity. In 2014, the Office for Civil Rights issued a questions and answers on Title IX and single-sex elementary and secondary classes and extracurricular activities. This guidance describes how schools with single-sex programs and activities should comply with a variety of equity standards to prohibit sex discrimination under Title IX and the U.S. Constitution. What Jeanette wrote is picked up in many of these, in this guidance, using Ruth Bader Ginsburg's same language, thank goodness. And it's also, this guidance that's specifically focused on single-sex education is also reinforced in various ways by additional guidance that came out in 2015 on the requirements for Title IX coordinators who are supposed to implement and make sure that people don't discriminate in education programs or activities that receive federal financial assistance that are covered by Title IX. And so remember Title IX coordinators because they can be important allies, and there's guidance on their responsibilities that's very important. Unlike many other types of sex discrimination, sex-segregated public education is deliberate and under the control of educators, quite different from sexual harassment and sexual abuse. Thus, educators should ensure that any education programs or activities that exclude participation based on sex, including sexual orientation and gender identity, must provide an evidence-based justification that this segregation will improve the students' educational outcomes better than gender equitable co-educational activities. So we need really good research and evaluation there to meet those standards. Additionally, there must be evidence that during the delivery of the sex-separated education, there is full equality for girls and boys, or as the guidelines call it, even-handedness, which is a nice common term, and that there is no sex or race stereotyping, and that all participation by both students and staff is completely voluntary. Now the legal standards are terribly important, and Monica will show how they're important right in our DC schools area. But it's also the reasons for objecting to sex-segregated education are based on very related and parallel and very congruent educational concerns. There is growing evidence that deliberate sex segregation is detrimental to students' achievement and self-esteem. It often increases sex stereotyping, and there is no evidence that sex segregation of minority students is better than comparable coeducation. There have been major research syntheses that show this. In fact, there is no evidence that girls and boys as a group learn differently, need to be taught differently, or need to be educated in separate classes. Similarly, there is no evidence that separating girls and boys decreases distractions and harassment from the other sex. In fact, sex segregation may increase some undesired behavior, including fighting and homophobia. Finally, students in sex-segregated classes do not have better educational outcomes than comparable students in equitably resourced co-education classes. And I have an article that will pass around. I actually have 2 pass-outs that we can pass out after our talks on the pseudoscience of single-sex schooling that addresses many of these issues very clearly, so you can share that with others. And we also have problems with sex-segregated public education. That's one of our FMF handouts. Both of these handouts are on our website if you need additional copies. So the educational concerns. And there's one other major type of concern, the economic concerns. Sex-separated education is actually more expensive in money and staff time than similar gender-equitable co-education. It requires additional administrative procedures to oversee the equitable treatment. It often provides duplicative services, facilities, and staff, specialized teacher training, and many, many more resources devoted to increased evaluation requirements to not only justify the initial approval of any sex-segregated education, but also to justify its continued existence, that it's meeting all of the objectives of even-handedness and not hurting people. So then it's also encouraging to know the following trends that may be helpful to support decreasing deliberate, publicly supported sex-segregated education. In the past decade, there have been steady decreases in sex-segregated private education, like Catholic schools or private schools, and in voluntary clubs associated with educational institutions that exclude participants based on their sex, sexual orientation, and gender identity. The strategies have helped, and there's some illegal sex segregation approaches include that we can all participate in legal objections, especially the wonderful work that ACLU has been doing. We've also found that often schools stop their sex segregation, especially their single-sex classes, if there's a change in educational leadership and the principal doesn't support it particularly because it's really a big hassle. And also, well-informed Title IX coordinators can stop the illegal use of sex segregation. And it's also very important for those of you and other feminists, people who care about equal rights, to pay attention, identify it, and stop it. And so we have to increase our awareness of where it's happening and the tools that we can use to stop it. And particularly, we need to know much more about what's going on in our own local neighborhoods, and that's a great opportunity for Monica to brief us on some of the scary things that have been happening right here in Washington, D.C.
So I feel like I just got like the best setup I've ever had. I want to preface this with, I'm the executive director of the ACLU of the District of Columbia. We deal with issues arising specifically out of the District of Columbia and represent its residents. And so, and prior to coming to the ACLU of DC, I was the executive director of the ACLU of Idaho for 6 years. It's just like DC. However, I'm joking. However, we did deal with, in Idaho, one of the types of sex segregation that Sue was talking about, which was classrooms within a school being sex segregated from the elementary, like all of those classes being segregated at the elementary level. And so what I'd like to do here is sort of a 4-step process. I kind of want to outline how we got here, and in DC, specifically talking about the Empowering Males of Color initiative and the Ron Brown School. I would like to then talk a little bit about the North Star Charter School and the North Star Charter School application, which has come about in this year. And then additionally, give you a little bit of insight into some of the things we learned as the ACLU being on the ground, and the community discussions and input we have had around this issue that sort of broaden the issue in a way. And then I like to be concrete. And so I don't want to leave without giving you some concrete action steps that you might be able to take. So essentially how we got where we are, we, just like other folks in DC, read in the Washington Post that the mayor was going to unveil a $20 million Empowering Males of Color initiative that would build a new school, but additionally have all of this wonderful programming to raise up Black and Latino boys in the district. This is an absolutely laudable goal. It is something that the ACLU, addressing racial disparities and discrimination, it is something that we stand for. However, our deep concern was, what was the justifications that are required under the law and under the Constitution and Title IX to say that the answer to addressing those disparities was actually sex segregation. So what we did was, a lot of what we do is we FOIA'd information. We tried to see what DCPS's justification, the District of Columbia's public schools justification for opening an all-boys school, but also it wasn't just an all-boys school. And I just, for those of you who haven't seen it, we actually ended up putting all of our findings in a report called Leaving Girls Behind, an analysis of Washington, D.C.'s Empowering Males of Color initiative. And I just want to pause here because, like a great many TV doctors, I am not a lawyer, but I get to surround myself with lawyers with great information. So I do understand the legal analysis, but the entire sort of legal analysis is in here. I won't read it verbatim for you. But we have to remember, in addition to the Ron Brown School, what was being proposed were also $5.5 million in Empowering Males of Color innovation grants. These innovation grants were not just tied to the Ron Brown School. These were actually grants given to existing schools to run male-only programs in the existing schools, some of which included introducing art therapy for boys who deal with trauma and loss, target areas to increase boys' participation in STEM and robotics. Additionally, an international travel program to introduce boys to other cultures and to get them outside of DC. and additional sort of support programs that when we saw them, we said, okay, these are all the great things that girls could benefit from as well. There was also the 5 for 500 mentoring through literacy program, so an additional mentorship program that was about $500,000, a Celebrating Males of Color luncheon that brought academic champions and honor roll folks together, and then additionally on top of all of that was the high school. So I think it's very easy to focus in on just the school, but what we're talking about, and I think what was really beautiful about Jeanette's explanation is that what we are talking about is something tangible, like access to a school, but what we are really talking about is systemic sexism that, kind of altogether keeps women out of access to political power, networking power, economic power, that plays out under a really good intention, but it's not well-founded, nor what the ACLU thinks is justifiably legal or constitutional. So what we did is we looked for the justifications, and in DCPS's analysis and their own sort of data, a few things kind of came to the top. Their own statistics on educational outcomes demonstrated that girls of color, as compared to their female white counterparts, were doing just as bad as male counterparts who were boys of color were to their white counterparts. So the answer here was not necessarily about sex, it was about race. And so in that data that we sort of found in the justifications, they also did not appear to have considered whether existing opportunities were sufficient for girls of color. They sort of went in, it's like bad science, right? If you know what you want the outcome to be, you only study the information that will get you to that outcome. And essentially, they did not, the literature survey that DCPS did not point to single sex as a solution. Several papers recommend targeting boys of color, but they did not support excluding girls in programming. They did not research whether single sex was the solution. And in here, if we think about these schools and the programmings, it was interesting listening to Sue talk about, the economics of this. These are programs that are highly intensive. You get a class of boys, you build them a school, you put all this programming around them. If we did that with a lot of students, whether they were male or female, you might get better outcomes. So it's not necessary, correlation does not equal causation. And it doesn't appear that DCPS actually did the research to have an exceeding justification as to why single sex. So what happened? We wrote this report. This was, we felt a great report and kind of pointed to all of these things that the AG has said that he would vigorously defend the school. He sees things in a completely different way. We had multiple conversations. We have yet to see any admissions policy to the school. So we had several conversations. The chancellor would not meet with us. We started talking to DCPS through the AG's office on a phone call with the AG's office. They said DCPS, we asked them several questions. We said, if a girl can a girl apply through the lottery for Ron Brown High School? They said DCPS has told us yes. Okay. Second question, can a girl be accepted if she applies? DCPS told the AG's office, yes. Then we said, if she is accepted, can she attend? And they said DCPS has told us yes. So
Yes?
yes. So we thought, great. This is great news. I mean, if this is the case, we don't have a case, essentially. And a male-only high school is more of a public relations issue rather than a legal issue here, that they have called it this, that they have said that this is the case. But if girls were to apply to the school, they would be admitted. So we said, great. We wrote a press release, we posted the press release, and said that AG's office has changed their position on the policy. And the AG's office came out and said, well, the ACLU is completely wrong, we never changed our position on the policy. To which we thought, okay, now we're getting into a game of semantics. Maybe you didn't change the policy in the first place. Maybe it's always been that policy. So we have yet to see a policy. I'll skip to my 4 action items. We would love it if people could help us find out what the actual policy is, and that's one of the things that we're pushing for, is to actually see the admissions policy for Ron Brown High School. So when we released this report, we had several community sort of discussions, which I'll talk about in a minute, because I think it also sort of frames how we're thinking about an approach to the North Star Charter School situation, which is what I want to talk about next. So we're sort of in limbo with Ron Brown School for a few reasons. And the admissions policy is one. We don't have a client. No one has complained to us. So we found out earlier, I'm forgetting what month we are. It's been a long year since November. Earlier this year, we found out that there was a charter school application proposed in front of the charter school board for North Star Charter School, which is an all-boys charter school that would feed into the Ron Brown High School. It would be located in Ward 7 or 8, and which is where Ron Brown is also located. So there was a public hearing on April 24th of this year. There was a charter vote on May 22nd. The ACLU looked through the charter application for North Star Charter and actually submitted comment prior to the close of the public comment period, and we think it had some effect, because North Star Charter was approved, but approved conditionally. The conditions, which is the stage that we're at now, are pending sort of a legal analysis and North Star Charter Schools modifications to their existing plan to comply with that legal analysis. So the conditions within that the charter school board gave them was the legal analysis of they call it gender differentiated instruction, but I completely agree, it's sex differentiated instruction. If you look at the application, it says, boys' brains think like this, girls' brains think like this. So with a little it actually said, with a little asterisk underneath that says, for the most part. That's not a direct quote from their application, but
That's the gist.
That's the gist.
Monica, what did you say? I just didn't hear what you said. Girls what? Boys what?
Boys' brains think
Brains.
one way, and girls' brains think another way. So we've seen a lot of this in, I think this pseudoscience of single-sex education or schooling is a really good kind of starting point where we see, you know, boys' brains are very active, they need active things, girls' brains, you know, are much more nurturing and, they're
Passive? Are you saying
Yeah,
passive?
yeah, it's the very sex kind of,
I got news to them.
kind of delineations. So then additionally, some of the conditions on North Star Charter is that they also have to have an English learner plan in place. This is a school that they want to, you know, lift up specifically Black and Latino boys, and they had no English learner plan in place. They did not have strategies for inclusivity around their Latino students. And then finally, there is a component on gender inclusiveness. And I specifically say gender here because the question that we posed not only in the Ron Brown case, but additionally in the North Star Charter School case is, what will the school do with gender nonconforming students or students at some point within the school year or their school career that decide to transition? So it is a real question about gender, you know, in a sex segregated school. And so they also have to produce a plan saying what their response would be to a gender nonconforming student or how they would deal with students in transition.
Is there any precedent that you were looking at with, for example, Mount Holyoke? It seems to me that some of the women's colleges have been challenged with this particular question.
Yeah, I don't, so the question was, did we look at any precedent like Mount Holyoke? I think Smith has also been challenged with how do we deal with gender nonconforming students or students in transition. We didn't look there. Where we did look was what would be their requirements under Title IX in that aspect. But additionally, under the DC Human Rights Act, we have a very robust DC Human Rights Act that includes not only sex, but gender and gender identity, and what are the requirements under that act. We would also have included, you know, Title VII if 7 also included gender identity, although there have been conflicting court analyses of whether gender actually fits under sex discrimination. So those are some of the things that we looked at. So where we are right now is trying to figure out, first of all, who is providing the legal analysis. So is it the charter school board that is going to provide the legal analysis, and then the charter school then has to respond with a plan, you know, making sure that the charter school board is doing their due diligence and holding charters accountable to the law in their analysis? Or is it the charter school that gets to have the proposed charter school that gets to have their attorneys who can say, well, this is the legal analysis that we've done. Where is that responsibility and who is going to be in charge of it? And then additionally, we would love to see the modified program plan. So sort of monitoring the follow-up at the charter school board and those meetings.